National Insurance Clearinghouse, the marketing arm of Brokers Alliance, presents a Bravo video event, the Business Insurance Zone, dedicated to financial professionals who use insurance in their practice.
And on today's show, Basic Estate Planning with attorney Lou Shuntage.
And now the host of the Business Insurance Zone, the whiz of the biz, insurance columnist Steve Savant.
Well, welcome everyone to the Business Insurance Zone. We're broadcasting live to a nationwide audience of financial advisors right here in Fountain Hills, Arizona, home of America's largest fountain. And with me today, as he has been Monday, Tuesday, and he'll be with us the rest of the week, Lou Shuntage from Lincoln Benefit Life, attorney at large. Hey, Lou, welcome to the show.
Thank you, Steve.
Well, we're all estate planning, although I got to tell you, after yesterday's show, I don't know if I know what estate planning is anymore, because we were installing and inserting so much of what I would have conventionally thought is retirement modeling. And you were bringing it, oh no, this is the preamble to estate planning.
Yes.
So I was kind of taken back by that. You know, we were talking at the very end of yesterday's show, and I think a lot of people do like estate equalization issues, especially a closely held family. This is a great tactic. But I do think, we were off air when Lou was bringing this up, I do think a lot of our advisors think like I kind of think this way. Well, we'll just buy the life insurance and equalize everything, right? Make it all fair. But you said, no, that's not how you do it. No. Equalization works a totally different way. Let's talk about that, and then we'll get into what we want to talk about today.
Parents have a natural inclination to give the same amount to each of their children. Mm-hmm. But, you know, if you've got a case where one child is taking over the business, another child is not involved, doesn't want to be involved, or shouldn't be involved, and the parent's going to buy insurance to make them feel okay. Let's suppose the one child is taking the business over, is getting a business worth $5 million. Does that mean the parents have to buy a $5 million insurance policy and make the non-involved child the beneficiary? I say no. The one who's getting the business is getting responsibility. They don't make the business succeed, they've got nothing. This other child is getting the insurance, they're sitting back clipping their coupons. So perhaps half the amount of the business value is an adequate amount of insurance. Now, of course, not everyone's going to get a $5 million business. It could be a business worth, $500,000, in which case maybe $200,000 of insurance would be adequate for the child not involved. Another thing, sometimes people think, well, for this child who's not going to be involved, what I'll do is I'll just give them a passive interest in a business, such as non-voting stock, and I'll give voting stock to the child who's going to be running the show. Bad move again. Why? These family-held businesses, closely held businesses, aren't like public corporations that regularly pay dividends. The only way money comes out of these family businesses is typically as either salary or bonus, which means the child who's just sitting back holding non-voting stock gets nothing except aggravation, because they'll still get involved in filing tax returns, they'll be involved in financial statements and other issues. So the answer again is not giving the uninvolved child a passive interest. Buy life insurance, use the insurance to make it fair.
I think you brought up another really big point here, Lou, because you said it's like if I have these tale of two siblings, let's say the gal is totally involved in the business, her brother isn't. Now I'm just going to go ahead and say, okay, I agree with you. I'm not going to give the $5 million. I'm going to get half that because that's what they would have gotten.
Sure.
All right, so she's got half, but he has no headaches.
That's right.
He doesn't going forward. He's got $2.5 million. His brother owns. Yes, his brother does own the $5 million, but she has 2.5. He has 2.5. I'm thinking, well, that might be the better deal.
Right.
I mean, I have zero headaches. So I'm wondering if I could even go a little further and say, hey, listen, I know that you're taking on the business responsibilities, and it is a headache, and it does a lot, to be an owner in these days especially, it's very challenging. I'm going to go ahead and give some liquidity for this child so that the business so she can still perpetuate the business and give her a little jump start to keep it going. So you really, when I talk about equalization, I think we're not thinking about it correctly. It's what can I do to bring the possibilities so everybody wins, and that may mean somebody's going to get a little bit more here or there to make it equal in the overall, because I'm thinking, wow, 2.5, maybe I ought to take the money and just run, forget the business.
That could happen.
I mean, that'd be my way.
Sure.
Okay, well, but that's good. And again, remember, we have a whole doc on this, on equalization, and it's going to cover a lot of good points again. And of course, that's great as a preamble to insurance, life insurance sales, of course, and we do that all day long. What's next on your docket, Lou?
I'd like to talk about income replacement. You have a situation, let's assume, where there's been a family business and it's employed members of the family, outside members of the organization or key employees, and now you're going to sell a business to an outsider. Or even if you're going to transfer to someone closer than that, What's going to happen to these long-standing employees when there's a new management team in charge? Very possibly they'll lose their jobs. Now, can they go out and find a different job? Maybe. Can they make as much as making before? Maybe, maybe not. I had a case with a woman who owned a ranch, and she had a manager for decades who worked for her. She owned a ranch for 50 years, but got to a point where she couldn't ride a horse anymore. She was getting too old. And she realized that, the sensible thing to do was to sell the ranch. But she knew when she found a new buyer for the ranch that he was going to bring his own manager in. So what was going to happen to her manager for decades? She realized, well, I need to take care of him. So she took a part of the proceeds from the sale and used it to buy him an annuity, immediate annuity. Could have been a deferred annuity. He was going to be working someplace else. But this is not something you have to do, but it's a very decent thing to do to make sure that those who have served you for so long are fairly taken care of when new management comes in.
So how would I go about if I want to go in front of a business owner, and my goal is I'm a product vendor. I sell life insurance. What is my tactic to get in to state that so that he'll say, I'm interested in that?
I think I would simply say you realize that once a new owner comes in, that they're going to want to bring their own management team in. And it's entirely possible that your long-term employees, who could be members of your family, are going to lose their jobs. How do you feel about that? Do you think that you would like to do something perhaps to help them? We can do that by using an immediate deferred annuity. We might even help buy them a life insurance policy with a cash value that they could find useful. But just sort of a sense of responsibility and fairness to those who've been good to you.
And these are all kind of tactical exit strategies from a buy-sell point of view. When I'm looking at buy-sell funding agreements, and we have docs on all this, by the way. Again, we'll talk about that a little later on. Buy-sell, cross-purchase, wait-and-see trust, stock redemption. I mean, there's a lot of these. Those are the ones that eat probably about 85 to 90% of what I would call succession planning.
Sure.
Talk a little bit about, we talked about in buy-sells. I always find a confusion in small, closely held companies whether I should use a buy-sell agreement, because this matters for estate planning. This one I get. I actually get this one. Buy-sell agreements, cross-purchase, and this whole, I call it the secret sauce, wait-and-see trust. We'll let you talk about that because I know you like that. Stock redemption. Talk a little about when do I use these, because I'm confused. Should I use cross-purchase, buy-sell? Should I wait-and-see trust? How do I do all that?
Okay. First, understand something. As I said in one of our earlier broadcasts, every business owner is going to do one of three things. They're going to retire, they're going to die, they're going to become disabled. No business owner should ever want to be in a position where they don't know what's going to happen to their interest on their death, retirement, and disability. At a minimum in their planning, they should have a buy and sell agreement with someone to take over that business interest. Now, do you want to go cross-purchase? Do you want to go redemption? Do you want to go wait and see? A cross-purchase arrangement is one where the business owners, assuming we have more than one, agree among themselves that when one of them dies, retires, becomes disabled, the remaining business owners will buy that person's interest. And the members of the business, each of them who are participating in this buy and sell, they buy life insurance on each other. Well, right off the bat, if you've got 4 business owners, you need 20 insurance policies because of the multiple.
Right, to cover every contingent.
Exactly,
right.
Which can be a bit cumbersome, So that's one negative against a cross-purchase. One thing in its favor is the fact that because the remaining business owners are buying out the one who's departed, there's a step-up in basis for their interest. So if later on they sell their interest during their life, they'll pay less of a gain, a tax on the gain, okay? If you're looking for simplicity in terms of number of policies, then that's where the entity arrangement comes in. And that is a situation where the business owners contract between themselves and the business. Then one of them dies, retires, becomes disabled. The business buys the departing person's interest. And to fund it, the business buys an insurance policy on each person, which means one policy per individual as opposed to a multiplicity of policies. Problem typically is that because the business is buying the person's interest, the amount of ownership for each of the survivors goes up, but their basis doesn't go up. So if they end up selling out during life, they could pay more tax. Now, the point I'd like to make is you don't really know all the facts that are going to be in the ground until the sale actually takes place. So rather than trying to make a decision up front to go buy, sell, cross-purchase or redemption, let's use a wait-and-see agreement. And what a wait-and-see does is it allows you to postpone until the actual time of sale the decision as to whether to go cross-purchase or redemption. At that point, you decide.
Okay, so let me get this straight now. I don't know what I'm doing, or I'm not really sure how the future is going to go. I can make a document called the wait and see trust.
Right.
That document's going to have some number. I don't have to make the decision until I get to the point of death of one of the partners,
Right.
retirement of one of the partners. Well, walk me through this. I just want to make sure I understand what you're doing here. We have this doc, and again, if you want to order it, but I want to make sure all our advisors understand it. So am I actually talking about the business's worth at the time I write the trust, wait and see trust, or no, I'm talking about it in the future?
Well, I wouldn't call it a trust, first of all. It's a contract that's called a buy and sell agreement. Now, with a wait and see approach, we're going to have a document that is very similar to what you see in cross-purchase arrangements or entity arrangements. There are certain basic features. You're going to have the business owners participating, so they're identified who was going to be buying or selling. Then you have also a formula or some kind of a mechanism in there for determining a business's value. Okay, and what we're simply saying is that when we have an incident, death, disability, retirement, at that point, we're going to decide whether we want to go cross-purchase or entity purchase. Now, here's the one key point. We have to, in that case, have the life insurance purchased by and owned by the individuals. It would be a little complicated to get into the reasons for it, but suffice to say that it gives you the ability, whichever way you go, to not have problems with the transfer of value rule, which can cause death proceeds to be taxable. So I think the wait and see approach is, like, to me, a no-brainer. Why wouldn't you do that? Because you have flexibility. You simply have to realize that the insurance will be purchased by the business owners on each other. If then they want to go the entity route, they can transfer the policies or death proceeds to the company to fund the sale. If they decide to go the cross-purchase route, they already own the insurance to do that. One more thing. It's kind of technical, but if you have a wait-and-see arrangement, if they choose to go the route of having a cross-purchase, then, well, let me say this to you. I think the first right to buy the departing business owner's interest should be in the remaining business owners as a cross-purchase. If they decide they don't want to do it, then the business can buy the person's interest under the entity approach. The reason I'm saying that is that if you gave the first right to buy to the individuals, and they didn't buy, the corporation came behind them, then the corporation's purchase might be considered. So again, the first right to purchase should be by the corporation. I should have said that. The corporation doesn't buy, then the stockholders buy.
Well, I like the flexibility of wait and see trust. It's a wait and see doc that supports the buy-sell agreement. And again, this is all part of estate planning.
Yes.
Well, news for me. You're listening to the Business Insurance Zone, the talk show that talks about insurance in your practice. You can write us at the show, thebiz at brokersalliance.com, or toll free 1-800-290-7226, extension 147. Lou and I will be right back after the commercial break when you hear from our sponsor, Brokers Alliance, a leading authority on insurance in your practice.
Whether you're a professional planner pursuing a strategic partner or an insurance distributor seeking a national alliance, your business just went into overdrive. Now enter the largest resource of insurance products and services with unparalleled access to a worldwide audience of consumers through the National Insurance Clearinghouse, the marketing arm of Brokers Alliance, who can take your company and launch it into the stratosphere of success. With countermeasures, the most comprehensive carrier intel in the industry, the MASH unit with field triage underwriting and the premium tolerance test, the life insurance financial evaluation, the most rigorous policy review, and Bravo high-definition broadcasting with online social media. Your search just ended.
Well, welcome back to the Business Insurance Zone. I'm Steve Savant, your host, insurance columnist, financial color commentator, and in my own eyes, interviewer extraordinaire. Before moving forward with any of the strategies and tactics on this show, especially this show, don't forget to check in with your CPA, your tax attorney, or if you're FINRA licensed, your broker-dealer compliance department. Hey, if you want to call us on any quotes or questions you have on life insurance, annuities, DI, LTC, or group pension plans, 1-800-290-7226, extension 147. It's not what I know, it's who I know, and that's why I got Lou Shuntage from Lincoln Benefit Life, attorney at large, talking about, I thought we were talking about estate planning, but I guess you have to talk about business exit strategies and succession planning, because especially with closely held family companies, we have to talk about this at the front end before we can get to the estate plan. Lou, when we were talking about last one, I want to make sure, because this can be complicated, and I know that you had to be a bit detailed here because we got compliance always looking at what we're saying. Summarize what we just talked about here to give me bullet points, and then I'm going to offer what we can give in a doc for all of our listeners.
Sure. I was talking about a wait-and-see buy and sell agreement, which is simply a situation where in the document you postpone, or through the words of the document, you postpone the decision of what to do in regard to cross-purchase versus redemption or entity purchase. And in that situation, it's a great way to go because you don't know until the actual time of sale what are the facts on the ground that would favor one approach over the other. But be careful in this sense that when we write down who has the first right to buy the departing business owner's interest, that first right to purchase must be the corporation's. Then if the corporation doesn't choose to buy, then the stockholders can buy. The reason I say that is...
In that order?
Yes. First the corporation, then the stockholders. The reason is that if you gave the first right to purchase to the stockholders and they didn't buy and the corporation bought, the IRS might say, well, the corporation bought the departing owner's interest for them, and that's a dividend.
When I'm thinking about doing estate planning and having to deal with business succession as the front end to that,
yes.
Does it really matter what entity I'm talking about? LLC, S Corp, C Corp, partnership issues? Does it matter? Because if the estate, if the business is the bulk of the partners' estates, plural, is that an issue? Because does it make it easier? It's harder? I have to unwind it. I have to unpack it. If it's CS, partnerships, LLCs, is there any difference in what the entity is?
I think we have to look at is the reality of the situation. People don't start a business because of their estate planning concerns. They start a business and pick a business form which facilitates what they're trying to accomplish as a business. Okay, so I think we have to understand that they chose that business form for business reasons. Now, from an estate planning perspective, we have to adapt our planning to the businesses on the ground. So the first choice will be the business decision about what form to take. Then we deal with the estate planning consequences of that. And yes, certain forms of ownership are more complicated than others in our estate planning to deal with.
We have, and I think, a to-die-for spreadsheet that actually manages all the forms of corporations, corporate forms, and it grids it out. And it is again, it's not a technical brief. It's a kind of a get you in the game. It's kind of a checkerboard of looking at a grid that kind of walks you through this. If you want it, again, this or anything we've been talking about on buy, sell, cross-purchase, stock redemption, or in this punt, I don't know what I'm doing, wait and see trust doc, you can call us at 1-800-290-7226. extension 147, or write us at the show at thebiz at brokersalliance.com. And again, we're talking about all this is preamble to estate planning.
Right. I should add this though, Steve. As I mentioned, people will start a business and choose a certain form that facilitates the business they're trying to accomplish. That doesn't mean when we get into the estate planning part of it that we cannot change the form of that business if necessary in various ways to accomplish our objectives.
And we may want to do that. I mean, I've seen in some of our planning, we've had attorneys come to us and say, I know he had this entity, but now we've moved out of the business realm for the person. He's older now, he's planning for his estate. And so they're going to make modifications in the entity and its form. They'll take care of whatever taxable events are today because it's in their best interest overall going forward.
Right.
So I kind of like this because now we have to sit there and say, okay, not only do we have, we're looking at buy, sell, cross purchase, stock redemption, or even punting and going wait and see, but now we're even saying, hey, there could be some modifications and changes in the estate. As you said, in the original, when we set it up, we had our reasons, and it was almost all driven by revenue, taxes, and convenience for the owners. But now we're going to maybe have to change that for the convenience of the who owns it now as an estate issue.
Right.
So, I mean, this is all part of this. And again, we have tremendous relationships with many of our carriers who have great advanced teams. Lou's just coming from one of them, Lincoln Benefit Life, subsidiary of Allstate. Well, so what's on our next plate here?
Well, I think we want to talk now about what do we need to think of in regard to possible premature death of our breadwinner, head of the family?
Well, I love your line, premature death, right? I think there's a place in the good book where it says it's appointed every man to die and then the judgment.
Yes.
So I often wonder what's premature. So I guess I'm saying when I think about premature, it's my LE is supposed to be 80, 85, whatever it is.
Right.
Anything before that would be premature. All right. I just wanted to set the ground rules of definition.
Let me give an example. Let's suppose an individual and his spouse have a child who is an artist. Well, when you hear an artist, you oftentimes see a situation of a person struggling to make a living. They don't make a lot of money, and what they do make is infrequent. So in this case, our mother and father are subsidizing the income of this child who's an artist. Well, they can do that while they're alive. Okay, they can look at their situation and give them money as they need it. But what happens after both parents are gone? Do you just leave them money? Well, in the first place, it may be a child who's not good at handling the money. So leave them an inheritance, they might just go right through it. So there's another way of dealing with it, and that's what we call a spendthrift trust. And that's a situation the parents set up a trust. It can be irrevocable. They make gifts of cash to that trust. The trust buys a life insurance policy to parents, could be a second to die. And the parents make gifts of cash to the trust to pay the premiums. Now, when the parents die, the trust collects the death proceeds, and that money is in the hands of a trustee.
So am I hearing you right, that the spendthrift trust kind of is like, I don't want to use the word siphon, but I mean, it kind of distributes a little bit at a time or whatever I dictate to?
Whatever the trustee does. Now, the trustee will have certain guidelines in the trust as to how the parents think the money should go. But following those guidelines, the trustee is now in a position, as you point out, to feed money out to the child as needed. The beauty is this: as long as the money remains in the trust, the child's creditors can't get it. Now, okay, if you put cash in a child's hand, if the trustee gives the child $1,000, their creditors can go after it. So how do you deal with that?
All right, I want to make sure I understood this, Lou. So this could be, you're saying it can be creditor proof.
Yes.
Okay, so I like this because I cannot tell you how many estate plan in my last 30 years, just being I'm just a product guy, I'm not even an attorney, how many cases we've looked at over the years where we deal with 3 or 4 children and one of them is a bad seed, and they want to still give them something, but they don't want to give it to them right away because they know better.
Right.
Or what happens, and this is my bigger issue, I'm kind of curious, what happens when your in-laws become outlaws? I mean, what happens when you go through a divorce or, hey, that person does that person, and I'm in a community property state, and so are you in Florida. Yeah. So I'm just trying to think, how can I kind of think about that now?
Sure. And here's what I want to make before. As I said, if the trustee puts cash in the hands of the child's creditors can get it. So rather than doing that, let's suppose a child has a rent payment due at the beginning of the month of $1,000. Rather than giving the child $1,000 in cash the creditors could get, the trustee writes a check right to the landlord. Or if there's a car payment to be made, write a check to the financing company. So here's a way that money can be used for the child's benefit and is protected from the creditors.
Well, though you just described, now we're circumventing him even touching it to pay the bills due. We're just going to take all the complete economic issues of his life out of his hands.
Right.
Well, I think that would be an appeal to many people, many parents out there. If you're an advisor today, that would be, to me, a huge inroad in your next cocktail hour, right? You're talking to people who have children that really need help, even though they're adults. Here's an excellent way to come in with this. And actually, I don't know if I have a doc on this. Do you guys have a doc on the Spendthrift Trust?
We don't.
We don't. Okay, I'm going to have to look that up. I don't know if I do, but if I'll find it someplace on the web, I'll get it cleared through a couple of our attorneys, and we'll try to send this. I think this is an excellent idea. Excellent idea. What else you got, Lou?
Next kind of a trust I want to talk about is a special needs trust. Let's suppose we've got a child who's not like the artist, bad with money, but simply a child who's special needs. That
So he might have medical issues. He might have some kind of, maybe he was born with something that was an impairment.
Sure. Now, I want to point this out to you. According to the Surgeon General of the United States, 5% of our American children have a severe disability, an acute disability in the Surgeon General's words.
5%?
5%, 1 in 20 children.
That sounds awful high.
It is, but that's the
way
fact.
it is.
That's right. There's even a renowned pediatrician I understand from San Francisco who says, no, it's not 5, it's 6%. But still, somewhere about 1 in 20 children have got a problem. We could sit here and talk about 5 different ways that parents might try to deal with the trouble that goes with a special needs child, but the one that makes the most sense in the long run is for the parents to establish what's called a special needs discretionary trust. And essentially what they do is this. They set up a trust. It can be revocable or irrevocable. depending on their tax situation. And the child's a beneficiary of the trust. But when I say a beneficiary, the child is a discretionary beneficiary. The trustee doesn't have to give the child anything. Okay? The trustee is totally at their discretion deciding what to give the child. Now, why is that important? It's important because there are some government benefits out there that are described as needs-based benefits that become very important to a special needs child. Most critical among those is Medicaid. And Medicaid is not just doctors and hospital bills. Medicaid can provide other benefits, such as transportation costs or whatever, that are critically important to one of these children. You don't want to put money into a trust that's going to cause the child to be disqualified for these needs-based benefits. But by making the child a discretionary beneficiary of the trust, where the child is entitled to nothing but what the trustee chooses to give, then you're not going to disqualify the child for those needs-based. That's correct.
Wow, now that's a whole other area. I think that'd be a marketing issue that I might want to get into. I mean, if it's as high as you say it is, Lou, I'm thinking everybody's base. We're in a major metropolitan area. If I thought about 5% of all the children in the Phoenix area or in your Tampa area or so forth, that's a lot of children. So I think that's another target market to be able to sit there and give. This is giving a solace to some parents here. My child's going to be taken care of. They'll still get their normal government benefits by the way we set this whole up. This is why we're talking about estate planning. This is why we're talking about some of the issues we talked today, because it's not only good for your practice, but it's great for your clientele. Well, listen, you can view this show, all our shows, in HD 1080p, and you can go out to our site at www.brokersalliance.com, hit our on-demand section and watch all our shows, Monday, Tuesday show, and of course, don't forget tomorrow, Thursday and Friday. We're all over the social networks, Twitter, Facebook, LinkedIn, Vimeo, YouTube. You can watch all those shows. I'm Steve Savant. You've been listening to the Business Insurance
This has been a Bravo video event of the National Insurance Clearinghouse, the marketing arm of Brokers Alliance, one of the largest distributors of insurance products and services to a nationwide network of insurance professionals. Need insurance guidance? Call Brokers Alliance. The Business Insurance Zone, dedicated to financial professionals who use insurance in their practice.